Good afternoon, sir, ma'am. I'm Ian Readhead. I'm the National Director of Information and also the Chief Executive for the ACRO Criminal Records Office, and I lead on freedom of information and data protection for the police service. I'm joined this afternoon by Mr. Wise, who leads the National Central Referral Unit, which manages the responses from chief officers across England and Wales.
Well, thank you very much. It's very helpful, and we're very grateful for your coming and for your evidence. As I said at the outset of today, we're very interested to hear from some of the people who have submitted evidence to us. Is there anything that you want to say by way of an opening statement?
I was responsible for introducing freedom of information to the police service in 2005, and in general terms, sir, I would say that it's been effective in creating the right transparency and open governance that you'd expect from a police service and a liberal democracy. And overall, the Act has been good for policing.
Okay, thank you. Michael?
You'll have seen that we have some difficulty with the equipment. Good afternoon to you both. I shall address my questions to Mr. Readhead, but of course, if either of you wants to reply, that will be absolutely fine. In your written evidence, you state that the appeal system takes too long, frequently takes too long. If we were, or if it were possible to find a way of streamlining the appeal system, would you be in favour of that?
So I would. I think that it's really important in this environment that applicants are certain about what it is they're entitled to see as a result of a freedom of information request. Where there is a dispute, there's a whole sequence of processes which have to be followed, both through the Information Commissioner, who can have a decision notice, and then to the tribunals itself, and then eventually to the court as well. I think the danger is that there are some applicants who simply will not accept what they've been told, and it would be good to know that there was a position in that process that could be reached within a given set of time where the final adjudication could be made.
Well, that may be difficult, but I think you've probably heard some of the earlier evidence this afternoon and the discussion about the system in Scotland, which doesn't have a first-tier tribunal. I don't know if you want to express any views on that.
Well, the Scottish system, we've often looked at Scotland, and there's no doubt that some of the elements of Scotland are quite attractive, and certainly I think in that country there is that process which seems to reach an outcome at an earlier stage.
And you also draw attention in your evidence to frivolous applications and appeals, and you suggest that a greater readiness to award costs in those cases would be helpful. Have I understood that correctly? And if I have, do you think that would be a sufficient remedy in those cases?
We recognise the importance that there is a process of transparency and for us to actually respond to the legislation and employ the exemptions appropriately. However, a number of the requests that we receive are not, in our view, in the public interest. So, for example, the serial number of every police car engine that may be in a force are candidly absurd, or other requests about the level of complaints that we may get on a full moon. And so I would like to think that there may be a method by which we could effectively deal with such applicants. Now, earlier on you heard about Section 14 of the Act. We readily employ vexatiousness where we think that somebody fits within that exemption. I think it's right for us to do so because it gives us more time to then deal with the justifiable requests that we're receiving.
But you don't feel that you can turn down those requests that you've just mentioned on the grounds of being overburdensome and trivial in relation to the time and effort that would be involved?
There has been stated cases more recently, the Dransfield case is one, but at the moment it's sometimes difficult to deal with the person who is just making the ridiculous application, and it doesn't necessarily fit the vexatious definition within the exemption. Did you want to add
No, that's great. And the problem here is, of course, a reputation of the police service in turning an applicant down who actually may have a real interest in receiving that information. I think part of the Act should allow us or encourage us when we're training across the UK in encouraging our FOI staff to actually challenge the applicant and ask why they want the information. And I think that's the important part where we now, as part of our smarter approach in having a better liaison with applicants to deal with that.
But how would you like to see this? I mean, what changes that would make it possible to do, to deal with these cases? I mean,
support the Information Commission. I think that's ultimately where it is, because once we make that adjudication and the internal review appeal system, it's down then to the ICO, and I have to say, to a certain extent, they work in our favour, albeit recently with the IOCO case and the surveillance, it was well publicised within the press that we'd applied Section 14 vexatious, because the Home Affairs Select Committee, in our view, were already reviewing the way that we operated RIPA nationally, and we felt a real burden of the amount of requests that we subsequently received, when in fact there was a number of bodies that were already looking at this in an independent status, and therefore the Act, is it really there for us to try and give out some of this information prior to independent inquiries carrying out their role as well? And to us that's a vexatious approach, but it wasn't seen that way.
There's something else in your evidence which you may have had this kind of situation in mind when you mentioned it, and I'm not sure that I entirely understand what you mean, because you say the time has now come where a real analysis of the true and pure motivations of some applicants should be addressed. What exactly do you have in mind, and how could that be incorporated in the Act? It's quite difficult to see how that could be done.
I suspect, developing what has just been said to you, about 35% of the requests we receive are from journalists, and we fully recognise the right of journalists to understand what the police service is doing. But journalists also act as campaign groups, and they can align a whole sequence of questions asking the same question time and time again of different forces in different locations. And I feel that we need to be alert to how that can erode, again, our capability to give a proper answer and to give it once without finding that then another journalist asks a not hugely dissimilar question, but just slightly changed to make you go through the whole question, the whole process again. And that's onerous, and it takes a lot of our time. It's disproportionate when compared to the other questions that we actually get asked by applicants.
Could I ask, do you publish all of the answers that you give to FOI requests?
Yes, we do.
In the majority, yes, we do.
Yes, we do. Although I have to say, it's a weakness on my part. I always try to convince my colleagues when we introduce this legislation that the more we put on a publication scheme, the less questions we would receive. And that's proved to be absolutely not correct. In year one, we had 15,000 questions. Last year, we had just under 50,000, and we put a huge amount of information into the public environment. So it doesn't in any way reduce the level of applications.
But doesn't it help to deal with those where there are multiple questions which are basically asking the same question? Can't you just refer them to a previous answer?
We can't, because it's a different request. It's been slightly changed to deliberately get over the fact that we've answered the question before. So it's quite difficult for us to do that.
Have you ever tried to rely on Section 14 in that kind of situation?
Yes, we did, but we weren't successful in using 14 on this particular case.
And can you think of a way of widening Section 14 which might have enabled you to do that?
It's a trial. I think it's a test and trial situation, and understanding exactly how far we can push the limits in as we move forward. But the reality is, as Mr. Readhead has just said, that 52,000 requests is a huge burden on us at present, and forces just don't have the resources or the money to actually carry on. And part of our regime now, as I said, is about a smarter approach, trying to pick up the phone straight away to applicants, trying to be more helpful in explaining what information we hold, and then obviously trying to negotiate as to what we can then deliver. Because I'd rather see a happy applicant put the phone down as opposed to one who wants to maintain a request that then goes through all of this process in trying to get proper information.
But it'd be quite difficult, wouldn't it, if just going back to the evidence that you submitted and the bit which I quoted, it'd be quite difficult to identify motive as a criterion, because that might lead you to a situation in which the same piece of information was disclosed to one person who asked for it, but not to another, because some judgment was made that the motive was somehow superior in one case to another. That would be really difficult, don't you think?
I think so, you're right. Actually showing motive is difficult. But if as a result of the questions being asked, and if you did know from the sources of those questions, you can actually show that this was just part of a general campaign where slightly different questions were being asked time and time again of different forces in order to try and adduce a different response, then I just wonder if that might be a method on the basis of being able to show to the ICO, look, you can see from the way in which the questions are being articulated and the links between the people asking those questions that this is all one of the same thing that we've tried to answer from the outset.
Examples.
Well, on occasions we have campaign groups where they'll go away, they'll change names.
No, but sorry, what kind of questions are they asking that are causing you this unhappiness, this unease?
Off the top of my head now, I'm just struggling to find one for you.
Should we use the IOCA one?
Yeah, we can use it.
The Communications Commissioner issues an annual report in relation to how the police service have made applications under RIPA. It's the Commissioner's report, it's not our report. But we received a sequence of questions which were about that report before it got published. And although we made it clear that we could neither confirm or deny what was in that report for quite obvious reasons, we had that same question asked repeatedly.
Well, and did you answer it, or did you refuse to answer it, and was it taken to the Commissioner? What happened?
Well, with some of the forces we refused and applied Section 14, which was upheld by the Commissioner.
It was upheld.
Which is going to be published is one of the categories that's exempt.
Can I ask two questions relating to cost? What do you know the overall cost of answering FOI requests to the police service in England and Wales as a whole?
No, we've always used the work that the MOJ previously did, which was about 250, I think, per request.
About?
I think it was about 250. Yeah.
Times 50,000?
Yeah.
Yes.
Right.
I mean, some of those are repeat questions, so
Yeah.
a journalist may submit 43 forces the same request, so we count that in with our...
Now, however you categorise them, have you made any attempt to categorise those requests into broadly vexatious and broadly not vexatious requests? What proportion of the requests that you have received would you estimate fall into either the vexatious category or your own category in your written evidence of not having a true and pure motivation, whatever that means?
Oh, I would think vexatious requests are easily less than 3% of all requests.
Right. So it's a very small
It's
proportion.
a small amount.
And leading on from that, as I understand the position, costs are only awarded if they have been wasted, not if they're vexatious. Is it your view that there should be a situation in which the Commissioner, for example, can make an order that the requester pays some costs where the request has been disproportionate? And if so, what optimism or otherwise would you have about collecting those small sums of money? Is it realistic?
Well, I think it is a matter for the Commissioner, clearly. My optimism is that the administrative cost of trying to collect it may outweigh the actual award that's been
I
given.
feel so, yeah.
And we're seeing that already with subject access. So,
Could I ask a related issue, which is about the calculation of costs when assessing whether the cost of processing the application, not about fees, but the cost of processing the application is within the limits. We've had some evidence to suggest that the items that can be included in that calculation, for example, exclude the time it takes to read documents and also excludes the time it would take to redact documents. Do you have an observation about that?
I think we would like that included in that. I think we submitted that to the Select Committee previously. You have to realise that a lot of our stuff historically is still paper records, so you're talking 13 to 100 files in some cases. It's a substantial amount of work. There's a presumption out there that we can push a button and information is produced in seconds, and of course the reality is that just doesn't happen. And this is the work that we try to do with the journalists is explaining how some of this works in the background, so we can have a level of negotiation, because that's the only way forward. Things aren't going to change, FOI requests are going to increase, resources are going to decrease, and we've just got to find a better approach. But in general, I think the position is we think the Freedom of Information Act is relevant to our business, and we can comply with it.
Can I just pursue that for one further question? How much of some redaction has to be done for legal reasons? Would I be right in thinking that in terms of the kind of documents which those you represent have to submit, that can happen quite often? Can you give us any idea of how much of a burden that can be, the need to redact for legal reasons?
Well, in those cases, clearly we have to be very careful that we do not disclose things that could be prejudicial to the investigation of crime or bringing offenders to justice. And in those kind of cases, it does take time and care to ensure that we've sufficiently redacted documents so as not to disclose anything which may inhibit our future policing requirements.
The reality is some of our disclosures are that intense in a paper record. So every single piece of paper has to go through and be redacted. That could be one request. And you can imagine the amount of time that takes to deal with. And there's no recognition of this. This is part of the problem in the background, because at the moment we can't do anything about it.
And I would want to add, because we've mentioned journalists several times, the majority of journalists actually do understand the legislation, and they do understand the time it takes, and do work with us in refining exactly what it is that they want. And what we do encourage all of our staff is ring people up and ask them. Find out what they really want to know, and that can save you considerable time in reviewing lots of documents when in fact it's just a single piece of information.
Is how much of your material goes to the tribunals?
Substantial increase in the last couple of years, certainly. I think it is because of the process allows this. So that's a frustration for us, because on average it's about £9,000 or £10,000 for us to seek legal advice and have counsel representation. We're actually working on the basis of having some of our FOI staff trained to actually give the evidence and not employing legal counsel as a cost saving, but that's a drastic step forward. But at the moment there is no barrier to stopping anybody having their day in court on.
But is it typically because you take the Information Commissioner's decision to the tribunal, or is it because the requester takes the information decision?
In most cases it's the requester. It's very rare for us to actually challenge an ICO decision.
Okay. Is there anything else you would like to add?
If I didn't make the point, we still think that behind this application process it should be free. We would not wish to see any charging imposed. For all of what we may say to you today, we think it's really important that members of the community can make freedom of application, freedom of request to us and not be charged for doing that.
Probably one last point was talking about the safe space that you were referring to earlier with Mr.
Yes.
Graham. And I think this is one of our issues, is understanding and allowing senior staff to have, when we talk about information, I think drafts in particular should be safe space material. And I think if anything you were considering with regard to the content of what actually information is, drafts to us would be something that we would ask to be protected, because until that work is undertaken, we see a lot of problems, particularly say over financial issues within the police service, where staff members are trying to jump on board and understand what's going on in the background before any decisions are being made about redundancies for issue. And again, that just doesn't allow normal work to be conducted in the background first.
Do you receive many, and finally, do you receive many what might be termed commercial requests of people wanting
Very classic and obviously...
about your computer equipment or...
Yeah, constantly, mostly IT related.
Yes.
Another individual who asks for crimes in schools, and then he writes to the school and offers his secure blind systems. We get those on a regular basis. So there's a number of cases in the background, but it is mostly IT, I have to say.
Okay. Thank you very much.
Thank you, sir.
Thank you very much.
Thank you, Mark.
Something. Good afternoon and welcome. Thank you for your organisation has been the intermediary of providing us with a very large number of requests from the public. I'm tempted to say we're very grateful. I'm also tempted to say that it has extended the length of our inquiry a little, as of course we're having to give them all appropriate attention, and it's probably no underestimate to say that this is an industrial process dealing with the number of requests that we have had. But it's a very interesting part of this. Do you have any introductory remarks to make, or could you give us a broad outline of what you think of the conclusions and, in a sense, the story that is coming out of your work?
Absolutely. So, first of all, my name's Blanche Shackleton. I'm Campaigns Director at 38 Degrees. I'd like to thank you very much for inviting me here today. Our membership also absolutely delighted to have an airing on this stage. To give you a little bit of background, 38 Degrees is a movement of over 3 million people in the UK who believe that our society could be fairer than it is, and that democracy is better the more that people get involved. When we first found out in the summer that the government planned to review freedom of information, we added it, the staff team added it to a weekly poll that we send to a sample of 50,000 of our members. And we ask them to rate, the importance of the things that we could be campaigning on. Ever since freedom of information has gone into that weekly poll back in July, it's been ranked in the top 5 of issues that our members want to campaign on. They feel extremely strongly about it. I think the 2 key reasons being that they feel that transparent government is incredibly important and encourages a greater public trust in government, in what's going on sometimes behind closed doors, and allows them to see more of that. Almost 200,000 people have signed our petition asking for Freedom of Information Act to be protected. I know that you had 30,000 responses or around that. When I wrote an email to our membership last week saying I was coming here, and since then we've had 86,000 responses. Yep. So I've got quite a task ahead of me today in terms of distilling that, but we've been working very hard to try and pull some themes out for you. But we will be more than happy to provide some more evidence for you at a future date if you have any further questions based on further distilling. No, absolutely. Also in the past week, we've had 190,000 people sign a petition asking for the Freedom of Information Act to be extended to include private companies and charities providing services for the government. Yeah.
Thank thank you, that the Commission has asked, with a couple of introductory questions that you designed yourself. Mm-hmm. Could you just explain how you think about engaging your membership and making it easy and clear for them to then engage with the topics?
Absolutely. So firstly, we were in contact with your committee about the questions that you were asking, but I think in general our approach to this is always what is the simplest way of trying to find the information that, in this case, the Commission is seeking, and what is the simplest way of people feeding into this process and to any democratic process that allows you, just with your opinions, regardless of whether you've had prior experience. A lot of our members have had prior experience of freedom of information, but also a lot of our members have just read things in the newspapers, for example, and that is why freedom of information is important to them. So we've really tried to boil it down into its simplest form, and also tried to explain from what we can perceive from newspaper reports and that kind of thing, what we believe to be the government's intention when they're looking at different parts of this law, so that our members can see what it is that they're feeding into.
So I can see that your first two questions, as it were, separate from the questions posed by the committee. Why do you think freedom of information should be protected, and how do you think government transparency could be improved? Are, as it were, general encourages into the subject.
Yeah, absolutely.
A number of your respondents responded by saying, as you have subsequently highlighted, that FOI should be extended to private contractors who provide public services. Were you surprised that that response came in at the top, as it were, as a very specific response to a much more general question?
I was quite surprised. I think that we've heard over the years that our members feel that private companies playing an increasing role in delivery of government services without the same checks and balances in place is a worrying trend, and something that they want to put a stop to, particularly in relation to private companies providing, let's say, NHS services. Our members have always expressed a desire to have a greater understanding of what is going on and the decision-making processes there. It did surprise me to see it coming quite so high up, and is the main reason why we then have capitalised by seeing how much member opinion is behind that, and have been very pleasantly surprised by the numbers of people who are calling for that, and for charities as well, to be brought into line.
Could you then give us a little bit more flavour as to the range of responses in this area and what they are more specifically asking for?
Absolutely. So if you bear with me one moment. So our members have said that any private company or charity receiving public money or providing services for the public should be subject to the same FOI laws as public bodies. They have also said, they've talked in particular about not seeing there as being any particular burden on doing that, seeing that as simply bringing into line rather than an unreasonable request. And I've got some quotes here. So, for example, John from Rutland and Melton has said, indeed, any organisation charged with providing public services or whose services impact upon society and the ordinary citizen should be subject to FOI scrutiny. It's been very straightforward that people have just come behind that. That is very, very reflective of what a large number of our membership is saying.
Can I just take up a point about charities?
Absolutely.
As you know, there are many very small charities, often with a turnover of less than £100,000 a year, providing small amounts of public service, for example, in the mental health field or in the legal field, for that matter, providing pro bono legal services. Is it really your view that those small charities should be obliged to comply with freedom of information requests about their everyday activities?
As I say, it has been pretty unequivocal coming from our members that charities and private companies providing these services should be subject to freedom of information.
What's your judgment? Is it your judgment that small charities should be subject to this kind of scrutiny, or would you accept, for example, that albeit some charities might be subject to such scrutiny, there should be a financial lower limit set below which they should not be scrutinised.
My judgment, and I can only speak from our members' behalf and the data that I've seen there, is that I believe that some of our members might be open to considering what you're proposing. I wonder whether having a conversation about it and breaking down some of the more specifics around the turnover of those organisations, I wonder whether what we might find is some more nuance in the results.
But can you help us a little more? You see, we have actually analysed the tens of thousands, in fact over 100,000 responses that we've received from members of 38 Degrees. It might be helpful to the Commission if you were to give us your analysis and judgment, having analysed those answers yourself, if you have done that analysis.
My analysis, based on having looked at the responses that we've received, but also a general understanding of having worked with 38 Degrees members for a few years now, is that 38 Degrees members are highly pragmatic individuals, but that the transparency of government, the transparency of the way that public money is spent, is extremely important to them. Do I think there is a balance to be struck? I think that some 38 Degrees members would believe that to be the case, yes. I also believe that it is for us sometimes to set principles and then to look at the policy that is being made and this is being come up with. What we've tried to do is feed in as best we can to that policy making process. But I think without some more specifics, what you're asking for is more specifics, but we haven't asked those specific questions. I would be very happy to ask those specific questions and come back to you with a more specific answer.
Moving on to one of the other subjects of the questions from the Commission, what protection did your members think there should be for information relating to the internal deliberations of public bodies?
So our membership in general said that any protections that erode the public trust in politics should not be considered. They could see examples. They could see examples where there were protections that could be put in place. For example, we heard time and again where national security is to be considered, then that's something our membership understands, but that there should be a presumption of transparency. So I for example, have, can read you, Chris Seal from Leicester West said, "There are no exceptions to having open government other than those which directly relate to national security. The public has the right to know what's going on and how decisions are reached. Secrecy simply encourages duplicity. Open government allows open debate and transparent decisions that can be challenged or supported by individual citizens."
So to push that a little bit further,
Absolutely.
Did your members think that there should be any protection, any safe space for information relating to the process of collective cabinet discussion and policy development?
In terms of the Cabinet, 75% of our members felt it was very important that Cabinet discussions in general should be subject to FOI. 16%, I should say, said it was fairly important, and the remaining said it was not very or not important at all. The overriding consensus was that FOI should apply even more so to the Cabinet as the most influential group of parliamentarians. The public, our membership, wanted to see what was going on there, wanted to have a greater understanding, wanted to see greater sunlight on how cabinet decisions are reached and how they're made.
I wonder if I could just pursue this issue of private companies and charities. I mean, I think that we've had a lot of evidence about this. Let's just, for the sake of this discussion, accept that in principle, FOI should extend to private companies and charities. Picking up the point that Lord Carlisle raised, there's first of all the issue of proportionality. Yes, if it's one of the major contractors or private hospital, but does it go right down to a small charity or indeed a very small two-person company? So I think and where to draw the line is tricky. There's also the issue of what kind of service we are doing. I mean, for example, if you take the health service, I think forever and a day, the health service has probably used private contractors for decorating wards, painting them. And no one's really interested in FOIing the painters and decorators. You've then got the people at an intermediate level, say the IT providers, which may well be private contractors. Are you interested in accessing the service that they're providing if it's one being provided to the public? And then there's the obvious services, which would say operations, I mean, surgical operations, where plainly they're standing in the shoes of the NHS. So I don't know if you've got a view now or whether you'd like to offer us a view later about essentially how you define what we're talking about.
Well, I think I'd like to do both. I can offer you the beginnings of my thoughts now, and I can certainly go back and we will trawl through the data and see what we have over that. In terms of proportionality, my view from having looked at what we've received from our members is that they feel very strongly that people who are, in the NHS example that you're using, providing healthcare services, people who are on the front line of that delivery who have large contract or who have very large financial contracts, both of these should be subject to the NHS, to freedom of information. On the point around kind of painter and decorator or IT, I will go and I will have a look through, because I wouldn't be surprised if we've had a lot more come in the past week than you might have had when you first received, because I think this has become a much more hot issue in that time.
On the basis, on the basis of the responses that you've been able to analyse, you gave us a weighting for collective responsibility. 75% said very much and 16% said quite a lot and whatever. Can you give us the weightings on the other questions?
Absolutely. So 93% of 38 Degrees members ranked keeping freedom of information requests free and open for anybody as very important.
I've been reading a mixed sample of them, because I thought that quite a number of them said that providing the charge was small. That they could.
We have a slightly so firstly, the statistics that I'm using today are only going on the survey that we sent out last week rather than the evidence.
Right.
So
Okay.
in the evidence that I'm speaking to, where I'm giving you more, it's a combination of both what we've received in the past week and also what you received. But any quantitative statistics that I'm giving you is based on a poll that we've subsequently done. 99% of 38 Degrees members agreed that freedom of information should be extended to cover private companies who are hired to run public services. It was 94% who said charities. The same should be true of charities. 75%, that's the cabinet one I've already spoken to. 88% of 38 Degrees members ranked it as very important that risk assessments are available to the public via freedom of information requests. That's certainly something that we've heard a lot about in the past week, I'm sure was reflected in your evidence. 92% felt it was very important that ministerial vetoes, that is executive vetoes, remain rare and have very clear restrictions. And
I mean, in particular, I read the ones that I have been through.
Pardon?
And in particular, the ones that I've been through suggested quite a lot of people were content with the veto, providing that there was judicial oversight.
That's absolutely right. That's what we've seen coming through loud and clear. And then finally, 68% of our members think that you should not have to pay to make a freedom of information request. And around the issue of paying, there was some interesting nuance, because actually that's the statistic that was the most split in our membership. And so what I don't have for you is £5 or £10 or anything like that. But what we have had is that any cost, the members who do believe that there could be a cost, say any cost, a charge, that's right, sorry, any charge must be proportional. And then we saw quite a lot of disagreement over what proportionality meant in those circumstances. And so I would say that that is an issue where we've been unable to draw a very clear consensus on where our membership stands.
Do you have any idea how many of you, the people who replied, have actually used this process, have ever been requesters or not?
I have, so when we asked our membership last year, and we asked a small, I think it was about around 60,000 people, around 3,000 to 4,000 of them said they had used freedom of information in the past personally. And so I thought that was actually relatively high. And then we've got some examples of what they have used it for. They've used it both for kind of private means for themselves. So somebody... I have a member from North Devon who requested some information about themselves from the DWP to help them with a tribunal case. Also Caroline from Dover, who used it to ask the Environment Agency about their plans if there was any fracking in her area. And so all sorts of different things our members have used it for.
Would it be possible to supply your questionnaire
Yes.
to us?
Absolutely.
And the numbers responding?
Absolutely.
And do you have any means of knowing the extent of overlap between, because you say you've accreted two separate responses, the ones we have and then this poll. Do you have any means of knowing what the overlap is between?
I can very easily find out for you.
Thank you. I think we've, in the exploration of those numbers, I think we've answered the next few questions. What we didn't touch on was what your members thought about the appropriate enforcement and appeal system for FOI requests.
Okay. So with appeals, as has already been alluded to, when we asked our membership about this, we not only asked them about the appeal system, but also how authorities would justify their decision-making. Because what we were hearing from our membership was a concern around the justification, that often you had kind of blanket responses that came back that didn't really explain what was going on or why the request hadn't been granted. And our membership felt very strongly that the authorities that had been asked for requests needed to justify their decisions, and that the public then needed to be able to appeal via an impartial, transparent and accessible judicial system. That was what came through as a very clear theme.
Yes, one of the frustrations, you get terrific insights from this material. One of the frustrations, of course, is that inevitably they're short answers that don't engage in the further debate. So you're not really able to give us any more feel about a discussion about the appeals process, or might you be able to?
I think there are some of these questions where we have seen that there has been more of a discussion, there have been more divergence of opinions. On the appeals process, I think there was less divergence of opinion. Our membership felt very strongly that this should be something that the judicial system was in charge of, that it should be taken out of the hands of politicians or taken out of the hands of government, and was... Absolutely. So we saw some mentions of the Information Commissioner. I think some in particular calling for the Information Commissioner to have more powers to call for the release of documents, but not a terrific amount on the Information Commissioner, which I would suggest is also down to perhaps people being slightly less sure of the role of the Information Commissioner.
And could you give us the same kind of feel about the responses around the use of the veto?
Absolutely. Sorry, bear with me. So as I say, members felt it was very important that vetoes remain both rare and have very clear restrictions on them. So I have some quotes which I think draw out some of the flavour that we were receiving from members. So some saying actually the executive should not have a veto and wanting all information out there. Others saying that in issues of national security, of course, a veto was understandable. My view is that that's where most of our membership lies, but that they would like to see a categorisation of things for which vetoes were not acceptable and were not allowed. And I believe that would cover a lot of their concerns about not enough information being put out into the public domain. I would say risk registers, as I know you've already talked about today, is again something that we've heard quite a lot about in terms of vetoing. It's felt by our members that risk registers should be published and that ministers should not be able to veto risk registers that are relating to bills that are going through Parliament. So I think this was a particular concern that came after the Health and Social Care Act, and the risk register for that, as it was a bill, was not released and was subsequently leaked, and was incredibly worrying to our members about the impact that would have, and I think really made people distrust the government's intentions when they were passing that bill, and was, I think, bad for the democratic process in that way.
And the last question from me, apart from the template for the questions that you circulated and the supply of the answers to us, what other nature of debate do you facilitate within your membership on, for example, this subject?
Absolutely. So all sorts. So in addition to set pieces like this, when we have wanted to dig in further to issues, we've often held focus groups with groups of members who have taken different actions relating to a campaign, so that I think what you're talking about and what you're seeking with some of your questions is the degree, is what goes on below some of those answers and what informs some of those answers.
Yeah.
And what we found useful in the past is focus groups to really enable you to have an in-depth conversation about these things, and is something I'd be very willing to conduct if it would be helpful to the Commission. Thank you very much.
Well, it's been a very interesting exercise to go through, to engage with your members. And we're grateful for some of the summary information that you've provided, which we would like to see, and maybe compared with the analysis we've been doing ourselves. But on the face of it, I think what you've described is very much been my response at the answers I have been reading.
Absolutely.
So thank you very much. And
it's a pleasure.
Any more summaries of things that you want to provide would be very welcome. Detailed responses at this stage.
So I'd be very happy to provide you, so obviously we have the statistics, which we'd be delighted to share, but we will be doing a more detailed breakdown of answers to these questions, which we'd be very happy to provide. And then if there is anything below that you'd seek answers to, then please let us know,
that
because
would be very helpful.
We have a lot we can trawl through.
Thank you very much.
Thank you.
Thank you.
He's here, apparently.
Hmm?
I think he's here.
Oh, he is. It's just in time.
Scheduled to finish with him at 3:40, but in fact, if he wanted to go until 4, that would be okay. That's extra time we built in case we were over.
Well, we mysteriously won the time.
Excellent.
Well, good afternoon, Gus. You just caused me a small amount of anxiety there as we were about to come to the end of the session, and I thought you weren't here, but just in time.
Second evidence session today.
Yes, well, I understand only too well. Thank you very much for coming. As you know, we have been through a process of a consultation exercise. We've had a lot of written responses, and we now decided that in some areas we needed to take some oral evidence, and we're enormously grateful to you for coming this afternoon. What was your other evidence session on?
That was the House of Lords Constitution Committee on devolution and the unified civil service.
This should be more relaxing. Lord Howard.
Is it possible for me to make an opening statement?
Of course it is. Of course it is.
Thank you. First of all, thank you for giving me this opportunity to contribute to the debate. I'd like to start by making clear that, in my view, the Freedom of Information Act has been important in opening up processes and decision-making in government, thereby enhancing accountability. In particular, FOI has led governments to be much more proactive in releasing information about why they have made certain decisions. I welcome this and would urge governments to go further and publish routinely the analysis they considered before reaching decisions. Ideally, this analysis should be made available when the decision is announced and ahead of parliamentary assessment of any legislation needed for implementation. I think the examples I point to will be the Monetary Policy Committee and the Office for Budget Responsibility, which demonstrate the power of that approach. I also do not believe requesters should be charged for putting in requests. Everyone should be able to make requests of public bodies. The difficulties arise if FOI discourages the proper analysis of all options. Civil servants should at times think the unthinkable and consider options which might, on reflection, be unworkable or undesirable. Similarly, ministers should be able in Cabinet to argue against decisions without fear that such views will later be published and used to attack the final decision. Both ministers and civil servants will need publicly to defend whatever decision is made. For ministers, this follows from the doctrine of collective responsibility. For civil servants, it is their job to talk truth unto power in advance of decisions, but once made, it is their role to defend decisions in, for example, select committees. If they did not, they would soon lose the confidence of ministers and cease to be able to do their jobs effectively. A difficulty with the FOI Act is that it creates a great deal of uncertainty about what could become public. The response to this uncertainty might be ministers not commissioning work, as in important contingency planning, or civil servants being cautious about which options they explore. Sections 35 and 36 provide exemptions for policy submissions, but all are subject to a public interest test. The difficulty is that it is hard to define what is meant by the public interest and how it will be weighed against counter-arguments. If your review, Mr. Chairman, could clarify how this test will be applied, that would be extremely helpful. Tribunals have accepted that releasing ministerial submissions which contain the full and frank advice of civil servants does damage the public interest in good decision-making. I refer you to Judge Angel's decision of the 28th of January 2015 in the case of DFE versus the Information Commissioner. Of course, each case has to be decided on its merits, but that does not mean there cannot be clearer guidance about how the balance of interests will be decided. As a great believer in evidence-based policy, I hope the review will help to ensure advice to ministers is based on the best available evidence displayed clearly and objectively. My fear is that the way FOI is being applied has led to ministers not commissioning some analysis and civil servants moderating the way they provide such analysis. It is, of course, extremely difficult to test whether my fears are justified because, by definition, we are talking about acts of omission, not commission. The other area that needs to be cleared up is the nature of the Cabinet's veto. I believe, and I think the Cabinet believed, that Parliament had expressly given them the power to veto a decision to release in exceptional circumstances. That power has only ever been used exceptionally, I think 7 times since the Act was introduced, and often to protect the sort of papers that would not be expected to be released until the time of the 30 or 20-year rule, such as Cabinet minutes on the Iraq War or Cabinet subcommittee papers on devolution. The recent Supreme Court decision suggests we were wrong, so it would be extremely helpful if this review could clarify when the veto could be used. Thank you.
Thank you very much in operating this equipment. Thank you very much for coming along this afternoon. You've just told us that you want to see published an analysis of the reasons why government came to a particular conclusion. Would that analysis then include the thinking the unthinkable, which you said civil servants should be encouraged to do, and all the options which were considered on the route to making that decision?
No, I think it would include the main options that were considered. So if there was something that came from left field. So I think it's quite right that there should be some blue skies thinking. But actually when it comes to it, when key decisions are made, I think there are generally 3 or 4 key options. And I think putting out some of the analysis about why a particular decision was made, what counter-arguments against that decision were considered, and why, on balance, it was thought that was the right option, I think will be good amongst feasible options.
So there'd have to be a distinction made by somebody or other between feasible and less feasible options.
Yes, I think that's perfectly reasonable. I mean, we generally start, I've always encouraged people to start off thinking as widely as possible and to narrow their thinking down. And in fact, quite often in submissions that go to ministers, you have tended to have narrowed them down to 3 or 4 options. I think the problem is, along the way, I want to get to those 3 or 4 options by having had someone think much more broadly and think outside the box, as it were, to use that horrible cliche. But some of those ideas may turn out, for example, to be illegal. And there's not much point, you don't want to put those to ministers.
What you've described it often comes under the label of safe space. And you've talked about safe space in some of your observations on the Act elsewhere. Would you like to expand at all on what you mean by safe space, and in particular, does it come to an end when the decision has been made?
Well, I'd say you very much want, as I suggested here, and I think this is an issue for ministers and for civil servants, I think ministers in Cabinet want to be able to, when a proposition is put forward, to be able to put counter-arguments to that proposition. They want to be able to do that in the sense of trying to improve the quality of the decision and its eventual presentation. But if doing that means that those arguments become public very quickly and could be used by the opposition to actually attack that final decision and to attack that minister who by then will be defending the decision under collective responsibility, as he must, then that seems to me to be an incentive structure which would suggest that that minister in the first place would not make those arguments in Cabinet. Similarly for civil servants, you want them to be able to say to ministers, look, you're thinking about this decision. Here are the 4 or 5 reasons why we think it's the counter-arguments. Here's the evidence we think weighs against it. And you want to be able to do that in a safe space, in the sense that you want to keep the minister's trust. You want to be able to say to them, look, it's my job not to be a yes man. I am telling you, here is some evidence that goes against your decision, and here are the counter-arguments that may well be put. And it's far better for the minister to consider those things before they come to a decision than afterwards. I think your point about when does this come to an end, I think when you've got the decision out there, then I think as part of that, ministers and the civil service together need to consider how much they publish. What I'm saying is I think it probably makes sense for rather more to be published routinely on the pros and cons and the considerations as to why you've come up with that final decision than is done at the moment.
But what opportunity would you provide for that ministerial judgment about what should be published after the decision has been made to be challenged. Would that be challengeable in your ideal world?
Well, I would say that sort of information is something that should be there, and that's a decision made by the minister. I mean, are you saying should there be an FOI request for other material? Should
Yes.
that be
Yes.
possible? Well, then I think I would like to say that other material should be covered by sections 35 and 36. That's exactly what sections 35 and 36 are for. Yes, exactly.
For 20 years?
Well, for as long as that exemption is held up. I mean, it may be that there are some areas of policy where it could be released much earlier.
But who decides?
Well, I think the Ministers of Civil Service together should make those decisions.
And therefore, the Freedom of Information Act would not apply to this category of information.
No, there could be applications, and I think then I would say, in my ideal world, we would say, look, I think you're asking for material other than this vast amount that was published at the time the decision was made. You're asking for extra information on top of that. We think that's covered by Section 35 or 36. And we go into the standard FOI process. But I think the problem with the current system is that once you go into that standard FOI process, no one knows what's going to come out of that. And what I would really like is the results of this commission to actually give us a lot more clarity on how those public interest decisions will be made.
Well, I'm going to come on to that, but I'm a little puzzled as to the position that you've expounded, because as long as the Freedom of Information Act applies, and as long as requests could be made for further information about what went into the decision-making process beyond what was published by the minister, you're left with the same kind of uncertainty that exists now.
If we end up in the world and nothing has changed, so if we end up with the situation we are now with respect to Section 35 and 36, I fear, will be absolutely right. What I'm arguing for is that I hope we get to a world where you have managed to come up with some wonderful way of ensuring that you've managed to improve the process. But if you don't, then I would say all the things I've said about people not wanting to commission certain research, certain questions, and it being made very clear that they don't want anyone to start thinking the unthinkable.
What help can you give us to come to your desired outcome?
Sorry, what?
What help can you give us? I'm searching for an approach,
yes,
which would enable us, if we wanted to do that, if we thought it was desirable, to reach your promised land.
Right.
And I'm struggling to find it.
Well, I think at the moment the public interest test is there, and it's interpreted by every individual tribunal in its own way. I famously was asked the question when the coalition was being put together. The two groups came together and they were going to have their negotiations, and they were talking about should they have the civil servants in the room. Would anything they wrote down be FOIable? To which I said, it's all, there are policy exemptions we could include, but they're all subject to a public interest test. And to be honest, because I am very uncertain about the way that is, I cannot give you an answer. To which it was very clear response, and this is very, documented. Right. Okay, thank you very much. No civil servants in the room. Therefore, we have no records. So this is a classic example of the FOI doing the reverse of what it was intended to do.
But absolutely, but I'm asking you how you think that example could be avoided in future, because if, as you say, the disclosure process that you've identified remained subject to the FOI,
yeah,
presumably the test which you would want the Commissioner and the Tribunal to apply as to whether or not that additional information should be disclosed would be a public interest test. And so where are we in a different position? How are we in a different position? How are we in a situation of less uncertainty than there is at the moment.
The way I would solve that is I would want there to be a rather clearer view about the potential costs of putting information out. The benefits are quite clear to some people, that they'll learn something they didn't otherwise do, often not quite as much as they think, but there we are. But there's no evidence about costs to this. And I would say, actually, if by releasing something, there's clear costs to the process of government, that actually by releasing this, you, the tribunal, should really consider very carefully whether you are improving the quality of decision-making.
I mean, isn't that just another way of saying, I mean, how do you assess this clear cost other than by making a judgment about the public interest?
Well, it is a judgment about public interest, but at the moment, the public interest, I mean, what does that mean? We need a bit more guidance about what constitutes the public interest, because I think at the moment, very little has been said about the problems of improving government decision-making, because you have got this situation where people have started to either not ask for information or not want to write it down.
And just on this issue of the coalition and this story which we're aware of, telling officials to leave, when you gave that advice, did you yourself have any advice from the lawyers about whether Section 35 or 36 would have actually engaged to protect the release of what's obviously very highly sensitive information?
I didn't, because I didn't think I needed it, to be honest, because if I'd had the advice from lawyers about does the veto stand up, does I'd had plenty of lawyers telling me that things would never be released, like cabinet minutes, and then they were. So, I would have been a bit sceptical about any lawyer's advice, if I'm honest.
Press this question, first of all, just to get some clarity. When you're talking about the information that has been released that could be regarded as damaging, I mean, how much information falls into that category? I mean, how many examples are there of information being released that is really damaging? I mean, I've been through much of the judgments on this, and it seems to me that in the majority of cases, those that the government thought that were really harmful, they deployed the veto. Many of the others, where the Information Commissioner has found against the government, were issues which came quite close to being issues of data or issues of relatively insensitive information. I mean, what I've struggled to find is actually clear-cut cases where a lot of information has been released and discussions of the kind that we have been talking about, which have been damaging.
I think the problem for all of us is that it's and it isn't so much things that are being released that are damaging, it's the uncertainty.
Right.
So nobody really knows.
So it's not that the material actually has been released, it is just the fear that it might be released.
And the fact that we are not certain whether the release of something creates a precedent, which means that whilst the release of that doesn't do anything very much, actually opens up a whole class of things which would be damaging.
But the Information Commissioner makes quite clear that he takes a case-by-case approach to this, rather than one of precedent.
Yes.
Do you think there's some clash here between the sort of culture of the bureaucracy versus the actual practice of the Commissioner and indeed the tribunal?
Indeed. And if we say it's all on a case-by-case basis, I'd kind of almost rest my case when I had to say to the negotiating committee, I don't know, because it's all on a case-by-case basis.
I mean, whilst I see the advantage of a generic category, isn't the truth that the range of government decisions is so diverse that you can't avoid them being on a case-by-case basis? I mean, just to think of 3 sets of decisions made, almost I became random. Decisions relating to fracking.
Yeah.
The Prime Minister's announcement earlier this week that there should be stronger language tests for people for whom English is a second language who are resident here. And, for example, change in the prison regulations to restrict the ingress of books. Now, now these are not cognate, are they? So, how, unless you have the broad principles set out in something like Section 35 and 36, and then a public interest test, how else can you make a balanced judgment in respect of those, except in the particular case?
And I would like to say, as you say, that the number of cases is incredibly wide. So, but there could be some principles. Okay, so a principle which said, actually, if we release this, that opens up a whole class of areas where some advice has been given which is going to be used in a way that would actually damage the quality of future decision making. That kind of principle, I think, would be very useful.
But that is something which the Commissioner could take into account in deciding the public interest and in deciding whether the public interest justified the disclosure of those documents.
Indeed, and if the Commissioner could be, you know, if we had some more guidance about precisely how they come to those decisions, and you know, at the moment, I don't have a clue when a case goes before an information tribunal. I have no idea if we're going to win or lose. I know I've got QCs that tell me great expense, certain things that might win or not. They're about as good at forecasting as.
But Lord O'Donnell, isn't that?
I won't mention the Treasury and no. Yeah.
Isn't that an inevitable consequence of the fact that you are relying in the end on someone's discretion? We've looked with interest at the evidence you gave to the Post-Legislative Scrutiny Committee in 2012. And you repeatedly there called for clarity and certainty, and you said repeatedly there must be no grey areas. Isn't it apparent from the discussion we've had this afternoon that there will always be grey areas, that there is no alternative to grey areas, and that desirable though it might be in your ideal world, you can never have clarity and certainty about these matters because there's obviously always going to be an exercise of discretion.
Well, there could be clarity, but I realise that that's not a world. You know, you could have clarity by complete exemptions, right? If we're not in that world, then what I'm asking you to do is minimise the grey.
But I'm still not clear how.
Well, I would say, along the lines we were talking about, are there some principles that we could apply? Is there some general guidance that could be specified which says, look, the public interest test isn't just something which every tribunal is going to come to fresh and look at the individual cases. They're actually going to have some principles that might guide them in this process, might allow all of us to know in advance what's covered and what's not.
Do you have any direct experience of ministers avoiding putting things into writing in order to escape the provisions of the legislation?
How? I mean, in a sense, how could I? Minister A phones Minister B on his mobile phone, and I'm not involved in that process at all.
Well,
that's what I mean. The whole evidence thing, you're asking for, it's virtually impossible to...
Not at all. You might have suggested to a minister that a meeting is necessary to discuss a particular decision, and you might have been told, no, I don't think we need one, and you might be able to form quite a good judgment that that was the reason why the meeting wasn't taking place. Have you ever come across something like that?
Yes, it's a short answer. And yes, I've had occasions where, I mean, I think the area of contingency planning, you know, I think there are various reasons why ministers are very reluctant to commission planning for outcomes that they do not want to happen.
But what, is that directly related to FOI? I mean, if you go back...
That's a combination of FOI and leaks, but let's be honest.
Yes, but because I can recall in the early part of the 97-2000 government, well before FOI was a serious prospect in people's minds, that there were some ministers who were very reluctant to go in for contingency planning on any basis because they were just reluctant. It was nothing to do with FOI. I mean, so I just wondered to what extent you think FOI has changed the climate?
I think it's added to it. It's another reason why you might be nervous about contingency planning. It's not the only reason, but it's a part of it.
And can you think of a principle which could be devised and applied to deal with that particular problem? Because it's not collective cabinet responsibility. It's not necessarily even advice of civil servants to ministers, which were the two categories of absolute exemption for which you called in your evidence to the Post-Legislative Scrutiny Committee. How would you provide a principle which would apply to that particular situation?
Well, if you're doing contingency planning for an event, and that event is at a specific date, and that date has passed, and nothing's happened, then it might be that you will be able to take a different attitude post the event.
Could I ask you to reflect upon the differences that you have either encountered or feel might result from the incentives of freedom of information, the differences between risk assessments and risk registers that are part of a policy development process and risk registers that might be part of your ideal presentation of policy post-decision in order to be transparent to the public?
Well, I think, I argue the case on risk registers that these should be exempt, and I think we lost. And as a result of that, I think risk registers will be rather more bland. And I think people will not want to put in those risk registers things that would be very scary. You take the, I think you've got particularly difficult questions in the financial area. I mean, if you say, look, I really think there's a risk that there might be a run on this particular bank, and that was subject to FOI, it would be completely self-fulfilling.
FOI is not, I don't think the Bank of England is subject to.
No, but it could, such a thing could easily be in a Treasury risk register.
You set us an unexpected piece of homework which slightly distracted me by suggesting that we should in some way seek to provide guidance about the meaning of the public interest. But the more I think about it, I think the less attracted I am by trying to provide guidance on the meaning of the public interest because, and I'll give you an example in a second, isn't it the case that our understanding of the public interest evolves and sometimes evolves very quickly as a result of changing events? My example is the Jimmy Savile case. The Crown Prosecution Service published a report on the Jimmy Savile case, and I'll declare an interest. I know about it because it was written by my wife. But it published that report, and in that report it was very critical of the actions taken decades before, or years before, by a previous incarnation, as it were, of the Crown Prosecution Service, completely different personnel. Now, those personnel were exercising a totally different set of judgments because they were looking at an issue which wasn't as high in the public mind, the damage it caused was not as well known as it is today. So by seeking to define what we mean by the public interest, or even issuing a set of examples, don't we really place a chilling effect on the virtues of a public interest examination and test, which is an evolutionary concept?
Well, I think where you think of it as evolutionary, I think of it as totally unpredictable. And that's my problem.
But isn't that one of its virtues?
No, I don't think so. I would say I would like to understand the principles behind it. You know, when you think of it from first principles, the public interest, is the public going to be better off as a result of this information being released? Now, there'll be some gains from having that information, perhaps, and there'll be some costs from the quality of government decision-making in the future might be damaged by that. And when you look at each individual case, you might be able to come up with a set of principles as to how you start measuring those costs and benefits.
Could I just have one question? I take you up on this point that you said that the publication of risk registers is going to make them more bland. But isn't it the case that people will later actually examine those risk registers, and if something goes wrong, we'll say, did this ever get into the risk register, and why not? and people who prepare risk registers, which turn out not to have been fit for purpose in the sense that they didn't get anywhere near some of the risks that actually did emerge, I mean, aren't they then going to be subject to some challenge? And I mean, isn't there an argument that actually says that the process of risk, the process of making these things available, whereby we can judge the quality of people's risk registers, that actually will improve the work that goes into them?
I think you would get better risk registers if people felt that they could genuinely write down what the serious risks are, right? Genuinely, and there was, as it were, a safe space to talk about those.
But the subsequent
really
publication is an important part
Indeed.
Of being able to assess the quality of the work that was done.
Indeed, and I will be all for subsequent publication. I would just want there to be quite a long lag between them doing it and that publication. At the moment, again, the lag is completely unpredictable.
Okay.
That's the problem, it's uncertainty.
But what if you had an event that occurred pretty quickly after the risk register was compiled, with intense public interest in the decision-making process which had gone into the lack of protection against that risk, as it turned out? Well, everybody would then want to know what the government had considered, and if a risk register had been compiled, there would be intense, dare I use the phrase, public interest in disclosing that risk register, even after a relatively short period of time.
And that might well be part of the principles that you would apply, which is that this risk register won't become public, but if one of the events in it actually happened, then there will be a strong case for releasing it.
Or
So
an
again,
event that should have been in it.
Sorry?
Or even an event that
should have been in it, exactly. So you would then get, that would be quite good guidance for, and you'd understand that.
Quite a bit of uncertainty, though, when you compile the register.
A lot less uncertainty than not having that guidance. It's not perfect, I agree.
Sorry, we're dotting about a bit. I was going back to who is qualified to define the principles of the public interest, and my colleague's example about Jimmy Savile. The more you think about public interest, the more you think about how it changes over time in reaction to experience. Also, it is very, very differently defined, sometimes only a few years apart, according to press interest. Social media is causing a very different sense of what the public interest is. So in these circumstances, in this difficulty of ever pinpointing it, it's a bit like trying to define the 10 Commandments of the public interest. Who is qualified to set down what the principles should be? Or might it not be better to understand that the public interest is a movable feast? It's quite a democratically informed thing. And that would lead me to be quite surprised that you had not said more to us about the clarity of sections 35 and 36. You've focused absolutely on the public interest in interpreting it. You haven't. You weren't here to hear the Information Commissioner, but he talked about his understanding of 35 and 36 evolving, and in his evidence he says, I think departments got better at it, I got better at it, I reissued guidance, which leads you to wonder whether the underlying legislation was clear enough in the first place.
Well, I didn't have too many problems on that line. I think where you're right about the evolving and the case-by-case part is generally on the benefits of publishing, right? So a certain issue comes up, it's a Jimmy Savile or whatever, and then there's a lot of interest in that, and it may have implications in all sorts of other areas, so it may be that there's a big weight there. I think where one might be able to improve matters is saying, yes, but in all of these cases, here are the steps you should go through to think about what are the costs of publishing, right? So if we even tied down that a bit better and said, so, what is it? So you're saying it's a case by case all the time. how can anyone interpret, how can anyone come to a view about this in advance, which is quite useful? Or are we to assume that it's just a complete random noise generator? So I would say, trying to be able to say, these are the sorts of things that the tribunal should look at in terms of the costs and to decision-making, quality of decision-making.
I mean, one of the exercises I've been going through is actually going through the decision notices and indeed the tribunals things to try to see if I could interpret from that what their approach was to the public interest test, because I think you're right that this is the centerpiece of this. I think there is very little, the debate as to whether something falls within 35, 36 or it doesn't is not a big issue.
No.
What this boils down to in the end is the public interest test.
Agree.
And I think one can see the way it's evolved over time, and indeed there have been some decisions by some of the tribunals which have enhanced that understanding. The Act, of course, is, in a sense, the way that it went through Parliament was a process whereby it was heavily changed when it was going through, and it was amended as it went through Parliament, and it does have, as a result of that, some characteristics of uncertainty. But we would be, we are searching, I think, is what a lot of this line of questioning is for, is to respond to your challenge of how to reduce the degree of uncertainty. I mean, you seem to be making the argument, which I have some sympathy with, which is that the outcome has not been terrible at all. There hasn't been a huge amount of information that has been disclosed that we would rather was not disclosed, but we would like to have had a greater degree of certainty about of which of those things that would be. But to arrive at that, we need, I think what the questioning is directing is we're still puzzled as to how that can be done, and whether it has to be in legislation, whether it has to be in guidance, whether it's government guidance or it's parliamentary. How is it that one actually brings that about?
Well,
because I think a lot of people could be much more relaxed about this within government if that could be achieved.
Yeah, indeed. And we had certain priors. I mean, that's the problem, that our priors have all been proved wrong. I mean, I had a prior that cabinet minutes would, be exempt in general.
But there's only one case where that's not been the
Indeed,
case.
but once you've got one case, so if
And
Prime Minister says to me, well, cabinet minutes can't be released, can they? I have to say, I'm not sure. I don't know. And then if you were to say to me after, I would have previously said, but don't worry, Prime Minister, you can use the veto. Actually, I would have to say now, well, I'm not sure. Actually, I don't know if you can use the veto. If you were to say the kinds of things that will, there is a process for releasing these already in cabinet minutes. There's a process where we do it for history and all the rest of it. That's there. That's a kind of well understood process, and that's the kind of process that the Information Commissioner buys into, that actually thinks that it would have to be something extremely exceptional to violate that principle. And if you read through the whole case that was put forward there, it wasn't that they were saying it was extremely exceptional. They were just saying this is a very important case. And plenty of other things that, in my view, would have been, if you release those cabinet minutes, there are plenty of other cabinet minutes you could have said should be released.
I think he was saying, wasn't he, that it was exceptional because it was so important. Now, the trouble with all these phrases, public interest, exceptional, whatever kind of phrase you choose, in the end, they all depend on the interpretation of that phrase and the exercise of the discretion to whom the power is entrusted.
But the idea that, I'd like to think Cabinet actually does do important work nearly all the time, and therefore to say it's important doesn't really...
Surely you'd agree that some's more important than others.
Some are definitely more important than others, but
Like
there's an enormous amount that's important.
Like going to war.
The Cabinet hasn't done its job terribly well in a particular situation. Do you regard that as being something which might go into the balance?
That could be a mitigating factor. I agree that if someone were presuming that something had gone wrong in process terms that they strongly felt was inappropriate, but actually and that release would have an impact on knowing whether that was true or not. Yes. I think that's the important part, certainly.
Again, going back to the question I dwelt on before, and forgive me for returning to it, as I've said, I'm instinctively unattracted by the idea of trying to define what the public interest means. However, I'll come back to the criminal law again with an analogy. When one asks a jury to make a set of difficult decisions in, say, a complex fraud case, you don't put the Companies Act in front of them, or even the Fraud Act, which is much shorter. You provide them with a roadmap, a written roadmap to reach their decisions. And I rather imagined that roadmaps to decision-making on freedom of information existed in the public service, but I suspect now that there are very few of them. Rather than seeking to define the meaning of the public interest, do you think it might be helpful if public authorities actually devised what I've called roadmaps to decision-making, sets of questions, so that when faced with these difficult decisions, there would be a question matrix which officials could follow, which would enable them possibly to reach more reliable and more consistent decisions?
Well, I think in some ways, I'd say it's a very different way of approaching the problem. You're saying, and we share the same objective here, to improve the quality of decision-making. And the question is, how do you improve the quality of decision-making? And there have been various attempts through my lifetime to do that, to make decisions more evidence-based, impact assessments, things that you publish at the same time, putting more evidence out there. My point early on about publishing even more was to take that to the next stage. So I think all of that makes sense, that the civil service, if anything, is the guardian of trying to do objective evidence-based analysis with clear submissions to ministers, laying out the options with recommendations. I remember former permanent secretary of mine giving us a template, timing, recommendation, advice, presentation, all those sorts of things. And there is in the civil service very kind of detailed structure advice about how you do those sorts of things. I don't know personally how that reflects your examples in local government, but I do think there's an enormous amount to be said for making there being checklists along the way to decisions and the like, and being as clear as you can about the nature and quality of the evidence which you're presenting.
If you remember, too, when you and I were working together, we made quite a big effort to try to separate, in a sense, the analysis and options behind a policy from the advice that we actually gave to ministers, so that we had some material which we thought was more readily available, and some that we hoped would be better protected. Has there been any attempt to try to do this in submissions in Whitehall over time, to try to separate the part that is really sensitive, which is the policy advice, from the actual analysis? Because it's that analysis, surely, that then should be published really quite quickly after a decision has been taken.
Well, if you were to follow my line about what could be published, I think this does pick up on what Lord Howard was saying, that it would give you, that analytical part would then be the bit that you would publish, whereas the individual advice you would keep confidential. There's no feeling that within FOI it recognises any of those distinctions. And again, it would be a joy if this review were to kind of give some clarity along those lines.
Guys, thank you so much for coming and having quite I hope you've found it as interesting a debate as I have, and it's been very worthwhile, and we're very grateful both for your opening statement and for answering our questions quite so straightforwardly.
Okay.
Thank you very much.
Thank you very much. Thank you.
Thank you.